I understand Brian's point is very relevant, and we cannot exclude those. In fact, they are technical judges. So would that suggestion, Brian, that Irun made,
Yes, I think so. We can't use judicial officers because that's got a technical term, and they're not judicial officers. But I think members in a judicial capacity is probably wide enough.
yes. Yeah, a microphone.
Or we could say that it could be judicial member or expert members, or members, judicial and expert members.
In fact, the best would really be, in my view, here in this we mention judges, and then we open a paragraph in order to explain that judges, depending on the jurisdiction, would include those technical judges or expert judges.
Yeah.
Because there is a risk here of, in trying to accommodate in the minority of systems, we change the nature of the majority. So we want to be mindful of the minority, and it's important that we recognize that. But in many parts of the world, we don't have that. So would it be possible, Brian, could you draft one paragraph for us with language that would include, in order to make sure that those experts that are judges, although temporary ones, that they can be members? Is it possible?
May I add something?
Luc?
Yes, because I think one of the concerns is that in Europe, and for example, the same is true with the European Court of the Court of the European Union, the function of Advocate General. They are members of the court, but they are not judges. They are delivering independent opinions in cases. So they are exercising a judicial function, but they are not judges in the strict sense of the word. And I think we should make it possible that they would be members. So I think they are playing a very important role in adjudicating environmental cases, including on the level of the Court of Justice of the European Union.
I think we agree on the principle. We just need the correct language. And I know that both Parvez and Kuma have suggestions, and I will ask Parvez first and then Kuma to make suggestions. And then we would leave that to Nick. He will, sort out. But could you please, let's collect the suggestions, and since we agree on the principle. Yeah, Parvez. Microphone. It has to be green. No, it's not working.
Mike.
Okay. I thought that if in Article 12, which is interpretation, you define judges as including technical and expert members of a court or tribunal.
No, not technical experts as such. In judicial capacity, because we have, my court, for example, has, I would say, I don't know how many experts we have, but they don't play a judicial function.
Okay.
They are there to assist those that are playing a judicial function. The people we are speaking about make judicial decisions or judicial or decisions that are judicial alike.
Yeah, okay.
Yeah.
I thought that
Yeah,
Justice
Kumar.
had the same thing.
Yeah, Kumar, you had a suggestion.
Yeah.
I think we could say, like in 5.3a, 1, individuals currently serving as judges, within bracket, which includes expert judges of the specialized tribunal and courts.
I think that would be great. Brian?
Yes, that would suffice.
Okay.
But I think we should pick up Luke Laverson's point as well, that Advocate Generals is
Yeah.
a very important role which should be included.
Yeah. Not many countries have advocate general, but I do favor the principle.
So,
Not advocate general as you do in the Netherlands. We have the Office of the Attorney General that works as both as a party and as custos legis. But the position of advocate general within Supreme Courts, not many countries, to my knowledge, have it.
Yeah.
But I agree with the principle. So let's ask, Justice De Leon, and then we ask Mansour, and then Nick Briner will be with the responsibility for finding the right wording.
Yeah, if we use the term judges instead of members in paragraph 1, that will be consistent with paragraph 2, serving as judges on other courts tribunals. So the same word is used in both paragraphs, paragraphs 1 and 2, judges.
Okay.
I think that'd be very clear.
Mm-hmm. All right. Mansour?
Yeah, my point is, well, if you look at 5.2a, the institutional members, and we're saying that you could have a nominee of judicial institutes and schools. Of course, they're not judges. So then the schools or associations or academies, if their nominees were to come and become members, they would not be judges. And they could become member of the governing council. So then we still have a window open where we're getting non-judicial members in.
It's true. There are countries in which the dean of the judicial school or academy is not a judge. It's not the case of Brazil, but I do know cases, and you do too, in which
In our country. Or
yeah.
mostly retired judges.
Yeah.
So that.
So should we? How do we solve the problem?
So then, as far as the institution, we need to be very clear, because if the principle, as it's set out in the preamble, is that we need to have an institution run by the judges, then the institutional membership needs to be defined. That can only be an institution that has judges.
Yes.
But in Guyana, I think it was discussed that these institutions are those that are servicing the judges, providing services for judges.
So, like academies could be servicing judges, but then
Yes.
they are not judges.
Yes, they are not.
And they become members, and then they become members of the governing council. So then, how does that figure?
No, I think Mansour Irum is asking a very valid question, or making a valid point. We have to clarify, in respect to the institutional members, that the institution, in case, has to be directed by a judge. Because otherwise, look, if we're going to have a portal with communication, secure communication among judges, how can we guarantee the security if we have known judges? So, yeah. So, but we are going to find, Kuma is making a suggestion, yes, Rangel, Nick Briner, I'm sure you're going to find, is there any disagreement on the principle? The most important thing is that we agree on the principle. The point that both Rangel and Mansour raised.
But I don't think it's necessarily must be led, these institutions must be led by judges, or, for example, in Norway, my country, the institution which is responsible for educating judges are not led by a judge. And still, I think it would be valuable for them to be possible to be a member.
Yeah, but here we are discussing membership, it's not partnership. in partnerships, we can have all those institutions.
Okay.
Here, we are speaking about membership with voting rights and the possibility of being voted into the council. So in one article, we say that only judges, and then in another article, we open the door or a huge gate for non-judges to be members, not partners. So that's the point.
One option, one solution I could propose is that we need not be so rigid and have a 10% or a 20% window for outsiders to be a part of this. That also conceptually brings in a little more set of ideas that is stronger than the partnership that you're talking about. Could we not possibly rethink and have a certain percentage on the governing council?
Mansoor, I'm sorry,
Okay,
but this
fine.
is not possible.
I was trying to find a
if-
solution.
I know, but here it's a matter of principle. We cannot have
Just trying to help.
We cannot have judges discussing legal matters in a portal, in a communication, or even asking questions to colleagues if they are not linked only with judges, at least in my country. And I suppose in other countries as well. So this is a fundamental, it will transform entirely the nature of this institute.
So I think that the define institutional membership. I mean, it's very
Yeah.
important.
Okay, so I think we agree on the principle, and then we'll ask Nick Briner to clarify this point, making it, we have already clarified in respect to the expert judges, and now we are clarifying in respect to the institutional members.
Right. My second comment on this particular clause is that while we are fixing it, then I find subclause 2 to be redundant. We could add that in one by saying that I think what we're trying to say is that we want institutions which are preferably institutions which deal with environment in subclause 2. But we don't have to have such a long subclause 2. We could just in one have, in the parentheses saying preferably institutions dealing with the environment. So that is just a stylistic issue so we don't need paragraph subclause 2, 1. And my third comment is that in clause B of 5.2, we could simply say that the governing council or the bylaws will determine the process of membership. That's all. We don't have to write such a long, we could simply say that the bylaws will provide for process of membership, or as prescribed, as we say. So that could be very,
So the change in 5.2b,
yes.
I would support that, because instead of the governing council, it should be the bylaws.
Please should say what the bylaws will provide for membership process.
Yes.
That's it.
But we keep C as well, right? Let's not
Keep
delete-
C, but in C, I just had a comment that we could get rid of a member. Suppose if a member has come up with anti-environment judgments, are we not going to say that we don't want him as a member? What if he's passing judgments which are against the environment? So do we have the facility to, blackball him and tell
Yeah,
him
but
that
here it's so general. Let's leave this further debate to the bylaws. I think that the bylaws will have to spell out all this, if you agree. Whatever is too specific, we leave to the bylaws. I think this was the point made by several of you. Any other suggestion?
The
Yeah,
same C may need a further clarification only to one aspect, where the person has become a member when he was a sitting judge. What happens when he gets retired? And does he cease to be a member? We need to
Yeah.
clarify, or it should be coterminous with his retirement. So that
Ye-
we could
yeah.
clarify, I think.
Yeah.
And
Because
the-
your object seems to be that it is the sitting judges who should continue.
Sitting judges, yeah.
one small comment that the institutional member would be a nominee of an institution, one nominee, two nominees, how many nominees?
What do you think? I think it's one, right? Say again?
He's saying provided in the bylaws. So we could have to say that the membership will further be determined by the bylaws, which I think B might take care of that.
Right. Yeah, Pauline?
Now, the consensus seems to be that judicial institutes will only be those that are headed by a judge. What happens to membership by judicial institutes that are not headed by a judge? Because do we want to lock them out as they are still providing services to judges? Can we then maybe in the bylaws have a provision that for those judicial institutes that are not headed by a judge, they can nominate a judge as a member so that they don't lose out? I don't know.
Yeah.
Because there are quite a number of judicial institutes that are not headed by a judge.
The idea, I think, is that those judicial schools that are located in other institutions, and some of them are completely separated from the judiciary, they can be partners. There is a provision on partnership. But here we're talking about voting rights. We are talking about the possibility of being elected. And so my suggestion is, Pauline, that we keep as it is, and then when we have the bylaws, we can, how do you say in English, to fine-tune it. Any other comment? Okay, so let's move then to Article 6, governance. Here,
One comment on 5.4, please.
oh, say again?
A comment on 5.4.
Oh, yes, please.
I see no difference between A and B. I mean, what's the point in having the two separate clauses? They're both members and they both have to do the same thing. Is there a different role to an institutional member and a different role for individual member? They're both supposed to help the institution. So I don't really
Nick
understand.
Briner. It seems that the rapporteur is intrigued by your question.
I'm just saying that what's the difference between 5.4A and B? Once you become a member, you're supposed to do everything that a member is supposed to do. So how would an individual member be different from an institutional member?
My recollection from the meetings and the discussions on these points from several days ago, originally there had been a longer list of potential activities or roles and responsibilities for institutional members. My sense of the discussion from that was that institutional members had a little bit of a different role in sort of facilitating the fulfillment of these activities than the individuals. I'm not sure if that has been very clearly articulated or whether people have particular ideas about how that could be constructed. There is a little bit of a difference in that institutional members have the word carrying out, which you don't have as far as individual members are concerned.
I saw that, but I just feel that once you become a member, then you're on the same footing. And otherwise you're creating distinguishing.
Nick Robinson, please.
Yes, I think Justice Mansour makes a good point that in the tightening up, you could in fact make the duties of members for individuals or institutions congruent here and bring them together. I think that could be consolidated.
So the suggestion is that the rapporteur collapse the two provisions into one.
No, may I
No?
say one? No, I don't think so.
Uh,
See,
Justice
I think
Kumar.
I was not present at that time when this was discussed, but I think there is a logic behind having a segregation between these two clauses, because an individual is not supposed to carry forward anything vis-a-vis himself in the place he belongs to, while an institutional member would have an obligation to carry out these functions in his institution. So there is a clear distinction between the two. For example, A judge can go back to his court, but he can't hold a judge's meeting and tell them how to go about the environmental issues. While a person who is member or heading of a judicial institution, he can go and include in his syllabi a chapter or a talk or a discussion, what he learns from the main institution body of the institute itself. So I thought we should place an additional obligation upon an institution who has nominated the member that they will hold the courses which are required. Maybe that's the reason, I'm not sure. But consideration of the House, please.
So how should we proceed? Do we keep them separated and sophisticate the language in order to avoid having two clauses that are so similar? Do you think this is possible, Nick? Nick Bryan.
So my sense, I mean, if I might add, and I invite corrections or other comments from those who were there in the meetings from a few days ago as well. I think this goes to the idea of why we would have institutional members in this organization and sort of what the purpose of having a separate category of institutional members is. And I think perhaps it could be clarified a little bit what that means, but my understanding, and I feel like the sense of those meetings a few days ago was that institutional members would be called on to take on a specific role that individuals might themselves not be able to
If I
fulfill.
may help, I think I take Justice Kumar's point, and I think what we can do is that there could be one, but additionally, the role of an institutional member is that he can also then involve his institution back home. That's an additional responsibility added. But while he's a member here at the institute, he's performing the same thing, but he additionally carries the responsibility of taking it home and ensuring that his institution gets involved also. That's what you're trying to say. And I think that's fine with me.
Nicholas Robinson?
Yes, I think this discussion is very good because Justice Kumar and Justice Mansour have brought that role of the Institute. But the Brazilian Association of Magistrates or the other national members in the International Association of Judges, for instance, as Nick Briner points out, did discuss with us that the part of it is they would help carry out some of the judicial work across regions. So I think that he's reminded us that the carrying out part of A is not meant to internalize things, but to be a voluntary contribution for the good of the Global Institute. So I think if the parties want to keep them separate, that's a good clarification. But we could also add this additional point about being in accordance with the approach of the Institute generally, if you're going to be an institutional member.
We could also have a general clause here and specify in the bylaws, because it's hard at this point to really find the precise language, and we might be tied up with something that is later on we regret. So I am inclined to believe that we could collapse and then make a reference, collapse the two, and then make a reference to the bylaws that could spell out, specify, go into the specifics. Yeah.
One easy way could be that if we keep B and just at the end add that the institutional member would have an additional responsibility of carrying out something like that.
Yeah.
So that covers it
Yeah.
all.
Okay.
All right, I'll take that noted.
I think Justice Kumar is happy with that, and I wonder if everybody's happy with this. If so, can we move to Article 6, governance? Oh, and I invite comments on Article 6. On the General Assembly, the Governing Council, and as I said, a lot of here would need to be specified in the bylaws, and in fact, several provisions make an explicit reference to the bylaws. Officers, committees, geographic regions. My only concern with geographic regions is whether we should make a decision on this now or whether we should leave this to the bylaws. We could just make a reference to regional, that the institute will be organized in geographic regions as established by the bylaws. So in case we need to update or to change, we will not be updating or changing the charter. We have to avoid having in the charter things that are so precise or would raise issues of modification later on that would invite us to change the charter itself. So that's my only comment here on.
I have a little comment. 6.2.h.
Masu, can I ask Emmanuel to speak first and then, yeah, thank you. Emmanuel.
Yes, thank you very much. I do appreciate your view that we should avoid points which would lead to amendment in future. But if we don't specify the geographic regions at the moment, how are we going to elect the 8 members? Because we need to specify it for purposes of election of the 8 members. So it's important at this point in time so that we can deal with the issue of election of members.
Yeah, if we decide, and this will be pretty soon, if we decide to instead of having the founding mothers and fathers and brothers and sisters, as you know, a sort of permanent body until we meet again. So if we decide not to do it, then we definitely will need to look at the regions. But if we decide, depending on the model that we the temporary model that we select in a minute, we might not need the regions. So let's keep this in, how do you say, in suspension for the moment until we discuss the Article 11 and 10. But thank you for the comment. So we don't make a decision on the regions now, but we combine it with those other articles. Yes, Judge.
My comment is on Article 6.1a. It refers to institutional and individual judicial members. Do we need the word judicial there?
Yeah, just 1 minute. 6.1a.
Yes. I think it should just be institutional and individual members. Do we need judicial?
Yeah, because we have already defined, yeah,
So we
absolutely.
can leave out the judicial.
Yeah. Accepted? All right.